The House Judiciary Committee will come to order. Madam Clerk, please take the roll.
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Pope. Here. Arbit. Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson. Here. Madam Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Clerk. Today, we have a lot of bills on the agenda, and because 3 of them are from our colleagues in the Senate, we're going to be, I see we have some of our members here from the Senate, so we're going to be going a little fast and loose depending on the order in which they get here. We're going to be hearing testimony on House Bills 4176 and Senate Bill 32. We will be taking up House Bills 4120 through 4125, Senate Bill and House Bill Senate Bill 18, Senate Bill 147. And I want to make sure that we have time for everybody to speak. We do need to get through scheduled speakers and vote out all the bills on our agenda. I'm going to ask that any speakers limit their testimony to, I'm going to say a maximum of 3 minutes. If you can keep it to 2 or 1, that would be awesome, but I want to make sure that we get to hear from everybody. So first I'm going to call up Representative Reingans to testify on her substitute bill for 4125.
Thank you, Madam Chair, and thanks to the committee for having me back, and especially thanks to so many partners that I got a chance to work with over the last week, formulating a substitute that's before you today. This substitute has 3 specific changes. If you take a look on the first page, if you have it printed in front of you, on line 6 and 7, we changed the language from a pupil may not be expelled or suspended for more than 10 days if for any event arising out of reporting being sexually assaulted, and we narrowed that and made it really specific to any action that an individual takes, a pupil takes arising out of. Instead of saying that, we made it more narrow by saying immediately preceding, immediately following, or that could be reasonably tied to the report. And then we also, later in that sentence, talked about an individual could be reporting or involved in this if they're a school official, staff member, or other individual. So we had heard stories and reports from students who experienced this issue that we're trying to prevent because some witnesses were fellow students who were engaging in things that they were worried that they might get expelled for themselves. And so we wanted to protect those students, but it could be anybody. It could be a parent that comes to the school or anybody. So we wanted to add those 2 things. So thanks to the partners for helping me thread that needle. And then we added section under subsection 2, which is on the second page, section D, starting at line 28, that brings the bill into alignment with other state law. And it considers the 7 factors. It really adds a formal recognition of the consideration of the 7 factors that need to be considered in Section 1310D of another part of state law. And we also wanted to make sure that it considers the report of sexual assault in addition to those required 7 factors for consideration for expulsion. So those are the changes, and I'm happy to answer any questions about that. But I hope that you'll vote yes to use this substitute, and then yes on the bill, 4125.
Representative Edwards.
Thank you, Madam Chair. What's the current process that's implemented right now?
So expulsion consideration has many factors and many circumstances in each individual expulsion consideration. And so right now, the process is that there should be an investigation of the sexual assault reports. And when there is consideration of expelling a student, there is supposed to be consideration of these 7 factors. And so we wanted to make sure that this substitute aligned our bill with current state law that asks those factors be considered.
Thank you.
Thank you.
I don't see any other questions from the committee, and what we are going to do is return to these bills at the end when we will vote. I will note I do have a card here from Tom Hickson from the Michigan Catholic Conference supporting the package 4120 through 4125. I also have Dr. Cheryl Kennedy on behalf of the Michigan Department of Education supporting here House Bill 4125. Thank you for your testimony. We will adopt the sub and vote it out later on in the hearing.
Thank you.
Thank you. We are now going to take up Senate Bill, let's see here, 147. Senator Geis. Thank you, Senator.
Good morning. Thank you, Madam Chair and members of the House Standing Committee on Judiciary for taking testimony on Senate Bill 147. Senate Bill 147 is a clear and simple bill to amend Sections 201D and 202D of the Elliott-Larsen Civil Rights Act in order to provide people with clear protections from discrimination and retribution for pregnancy, childbirth, the termination of a pregnancy, or a related medical condition under the Act. The Act currently has a provision specifying that the prohibition against an employer treating an individual affected by pregnancy, childbirth, or related medical condition differently from another individual does not apply in the case of a non-therapeutic abortion not intended to save the life of the mother. Currently, because of this specific provision, Elliott-Larsen has a carve-out that allows employers to fire an employee or engage in other retribution against the employee for having an abortion considered non-therapeutic and in the narrow definition of its use to save the life of the mother. Given the passage of Proposition 3 in November 2022, which codified an individual right to reproductive freedom in the Michigan Constitution, including the right to carry out all decisions about pregnancy, including abortion, an employer should not be able to treat an individual affected by the termination of a pregnancy differently than another individual, given the constitutional rights enshrined by Proposal 3 of 2022, which specifically amended the state constitution with Article 1, Section 28. It's therefore necessary to ensure that this loophole is closed so that employers who are hostile to abortion and believe they need to insert themselves in people's reproductive health decisions do not violate the state constitution and that individuals are protected from retaliation and firing. The people of the state of Michigan spoke loudly and clearly with the passage of Prop 3 of 2022, and it's now incumbent on us to ensure that laws related to it are updated to reflect the will of the people. Further, there's no other healthcare issue that an individual might have or a healthcare decision that an individual might make where an employee could be fired or otherwise retaliated against for utilizing. Thank you, and I urge support and swift passage of Senate Bill 147 so that we do not have a period of market uncertainty for employees who may need to terminate a pregnancy and how doing so may affect their employment status, especially now that Public Acts 6, 11, and 12 have been signed. And I will take any questions.
Thank you, Senator. I just would like you to be able to clarify for the record how an employer might differently treat an employee who has had an abortion.
Well, they could demote them. They could potentially fire them. They could reduce their hours. There are a range of employee-related things that an employer could enact on the employee who might have had an abortion or has a related medical condition from it.
Okay. Representative Fink?
Thank you, Madam Chair. Good morning, Senator. My question would be, there's been some concern that this change would require an employer with even a mission oriented around the pro-life cause to avoid abortions as a solution to challenging pregnancies, to cover in their health plans elective abortions or non-therapeutic abortions or whatever term we wish to use, but abortions that are not indicated for the reason of saving the life of the mother. That would obviously violate, in some cases, moral commitments and in other cases even religious commitments. So my question would be, do you understand this bill to require that kind of coverage by all employers, including, say, the Catholic Church or a crisis pregnancy center whose entire mission is about reducing the number of abortions?
So this bill is not about what benefits are required by an employer. This is specifically about discriminating for having had a medical procedure related to the reproductive health care. So that's the first part of your statement. That is not what this bill does. This bill is very specific to those civil rights protections for reproductive health care. Regarding the religious component, and I know that there have been Supreme Court, U.S. Supreme Court rulings regarding religious entities, but they've been very specific in the individuals who those things would relate to. So, for example, in Hosanna Tabor in 2012, that decision, the individual would have to. There are 4 factors that would have to be considered. So the job formal title, the substance of that title, the use of that title, and the important religious function, if any, that individual is holding. So the standard would be higher, I suppose, if it was for a priest versus if it were for a secretary. So whereas someone who is ordained and it's ministering sacraments or other ecumenical functions would probably be less protected than under this than someone such as a secretary whose job, no matter how invaluable she is to the institution, is not part of the mission of that institution. They're not performing any actual religious duties.
So just to clarify, you're saying you don't believe that this bill would apply to health plans regarding which coverages an employer is elected to cover, but you would say that this would prohibit, say, the Catholic Church from prohibiting an employee from continuing to work there after having an elective abortion.
This is not about health plans. That's an entire separate area of law.
I follow
This
you.
is about, and this is not about what should or what is currently covered under health plans. This is about the civil rights protections of an individual who is exercising their constitutional right for the bodily autonomy to make their own decisions and not be retaliated against by their employer for doing so.
Even if it's a religious employer, it would still apply.
You can't use religion as a shield for bigotry. So, yes.
Thanks.
Seeing no other questions before the committee, we have other people who do wish to testify on this bill, so thank you, Senator. After we take the additional testimony, we will then hold the vote and vote and we also will adopt the substitute.
Great. Thank you. Thank you, members.
I would now like to call up Ms. Genevieve Marnin from Right to Life of Michigan, and I note that you also have submitted some written testimony, which would be included in the minutes.
Thank you, Madam Chair. Leading up to, during the campaign leading up to the vote in November 2022, Michiganders were told that Proposal 3 would simply restore Roe. Yet, Senate Bill 147 would be a significant departure from the Michigan that operated under Roe v. Wade. The sponsor claims that Proposal 3 mandates these changes. It does not. Roe never tried to force those opposed to abortion to pay for it or support it. Prop 3's non-discrimination clause only applies to state actors, not private employers. Yet, Senate Bill 147 will apply to all employers, making them provide the same, quote, term, condition, or privilege, compensation, etc., for employment, which my term compensation would include employer benefits, including health care benefits. To an employee for an abortion, they would have to provide the same employee compensation, benefit, plan, and privilege for an abortion as they do for pregnancy and childbirth, including possible abortion leave if they offer maternity leave. Senate Bill 147 will cause many employers to violate their conscience by forcing them to provide abortion benefits, or else they will be forced to drop their employee benefits altogether, which will hurt families. I urge your no vote because there's no religious carve-out, there's no conscience protections in this bill, and it could force employers like Right to Life of Michigan to allow abortion benefits as part of their employee compensation. I do urge a no vote. Thank you.
Thank you for your testimony. I'd like to now call up Marissa Kovach from the ACLU of Michigan.
Good afternoon. My name is Marissa Kovach. I am the Legislative Director at the ACLU of Michigan. Thank you, Madam Chair, for bringing up this important piece of legislation today, and thank you, Senator Geis, for sponsoring this. I am testifying in support of Senate Bill 147, which will update the pregnancy discrimination provision in the Elliott Larson Civil Rights Act so that it no longer expressly allows for workplace discrimination against someone who has had an abortion. ELCRA is our primary state statute that prohibits workplace discrimination, and sex is a protected class within ELCRA. That definition of sex in this section of ELCRA includes pregnancy, childbirth, and a medical condition related to pregnancy, but it explicitly excludes abortion not intended to save the life of the mother. This carve-out is wrong, it is mean-spirited, it is intrusive, particularly in a state where studies show 1 in 4 women will have an abortion in their lifetime, and where a main factor in why someone may choose to have an abortion and discontinue a pregnancy is because they do not believe that they are financially able to support a child. The right to abortion is now constitutionally protected in Michigan, and to make a point, while that is tied to government actors, voters made clear where their values lie in November, and you are empowered to do the right thing here. Abortion can be life-saving, it can be health-saving, it can simply be what is the best choice for someone based on where they are in their life. But it is always a deeply personal and private medical decision. No one's livelihood should be at risk because their employer disagrees with their personal medical decisions. And no other form of medical care is singled out in our state's Civil Rights Act. In fact, no other place in our Civil Rights Act is there even a built-in license to discriminate. I would add, finally, if this isn't reason enough to support this legislation, this bill will bring ELCRA in line with existing federal laws. Title VII of the Federal Civil Rights Act protects employees from being fired for having an abortion or contemplating an abortion. So this legislation simply brings our state civil rights laws in line with federal civil rights laws. I mean, to conclude, this carve-out is wrong, and it's time to right this wrong. So we're very appreciative of the work being done here today, and I'm happy to answer any questions.
Representative Sergaloo?
Thank you. And I'm not quite sure who this question might even be directed to, but how might an employer obtain that information? And is there some right for an employer to even have that information?
I think it is confidential information, but you know, in all matters and ways that ELCRA protects employees. It's similar to pregnancy. It protects pregnancy. It protects all other forms of reproductive health care around pregnancy. It's just this carve-out. So in knowing that employees are very close to their places of work, that things that may want to be private in their lives can be made public because of the proximity, and this protection is important for that.
I just wanted to thank you for answering that, because that was just something that occurred to me hearing some of the earlier questions. Was just sometimes you can see someone's pregnant and they're not pregnant, but it would, in my case, I would feel like it was very private as to whether or not an abortion occurred, a miscarriage, or some other thing, and it just seems like it's a very private condition, and it strikes me as odd that an employer would even be allowed to access that information.
I think that's exactly correct. Thank you.
Representative Johnson?
Thank you, Madam Chair, and appreciate that question. I had the same question, Rep. Cerniglu. I just have a question for you. Do you think that religion is a civil liberty and therefore worth protecting?
Absolutely. The ACLU is a champion of the right to religious liberty. The very first right protected in ELCRA is religious liberty. Everyone has a right to practice their religious beliefs, but the ability to practice your religious beliefs does not give you a right to discriminate, and it doesn't give you a right to harm someone else.
So in this case, how would that be protected?
Well, certainly this bill, just like the conversation we have been having all session around ELCRA and what it does and does not allow, in line with that conversation we've been having around employment, churches, synagogues, mosques, all houses of worship maintain control over who they hire, private schools, religious organizations. But once an employer or a business owner puts his or her company or organization on the marketplace, they have to abide by many, many different rules enforced by the state, enforced by the federal government. And this is that. You do not ultimately have a right to put a business on the public marketplace and not follow our laws that we create.
So conversely, when someone is employed by an employer who maybe even campaigned for Proposal 3 or for abortion rights, and they have somebody in an employee that is on the other side of that issue, what are their rights, conversely? Since you're the ACLU, I'm asking you that.
Well, I think they again, if they are an employer, they have to follow state law. I will point to that it is already the law that you cannot discriminate against someone because they have contemplated or they have had an abortion. That's already the law.
Thank you. We now have to hear from Rebecca Master from the Michigan Catholic Conference.
Thank you.
Good morning, Chair Breen and members of the committee. As mentioned, I am Rebecca Masty with the Michigan Catholic Conference. Abortion is not childbirth, clearly. Yet Senate Bill 147 would equate elective abortion, the intentional decision to end a preborn child's life, with pregnancy and childbirth with respect to privileges of employment, which you will notice in Section 202, Section C of the bill includes a benefit plan or system. So that would include employer-provided benefits. No employer should be expected to provide abortion benefits just because they offer insurance coverage or paid leave for pregnancy and maternity care. No one should be forced to support another person's choice to have an elective abortion, financially or otherwise. This radical policy change violates federal constitutional and First Amendment rights of employers with deeply held beliefs against contributing to another's abortion and will undoubtedly lead to litigation. Finally, Proposal 3 was not a mandate on private businesses and should never be interpreted as such. Abortion rights supporters frequently mention that abortion is no one's business. Ironically, though, this bill will now make someone's abortion the business of their employer. We oppose Senate Bill 147, encourage committee members to vote no. Thank you for listening to our concerns.
Representative Wozniak.
Thank you, Madam Chair. What's your position, not your position, but your company's position on viability? When is a fetus viable?
Well, unfortunately now the constitutional provision has defined what viability is for the state.
And that had to change your company's opinion?
We don't agree with the current definition of viability, correct?
All right. Thank you.
Mm-hmm.
Thank you for your testimony. I'd now like to call Nicole Wells Stallworth from Planned Parenthood.
Good morning, committee. Thank you, Chair Breen, and also Senator Geis for sponsoring this important legislation, and thank you for inviting me here to speak today. My name is Nicole Wells Stallworth. I am the Executive Director for Planned Parenthood Advocates of Michigan. I proudly work on behalf of Planned Parenthood's patients, healthcare providers, and all Michiganders to ensure they are able to access and/or provide sexual and reproductive health care, including abortion, that is free from discrimination regardless of their employer, their gender identity, their socioeconomic status, and their zip code. Today, I am asking that you support Senate Bill 147, and in doing so, provide more certainty that Michiganders can make deeply personal decisions about their medical treatment within the privacy of their medical offices of their choosing, free from discrimination. No one should have to be faced with the fear of jeopardizing their quality of life or losing their job or being denied any form of housing or being kicked out of school or being retaliated against for any reason because they have had an abortion. No one should ever be shamed for accessing vital health care, and abortion is health care. 1 in 4 women will have had an abortion before they are age 45. Every pregnancy is unique. Therefore, any circumstance surrounding pregnancy, physical health status, relationship status, or any of the economic factors that go into making the decision to have an abortion can be soundly codified through any form of legislation. A study published by the Guttmacher Institute showed that 74% of abortion patients said that continuing the pregnancy would interfere with their ability to work, attend school, or care for their dependents. We have heard these stories time and again from so many of Planned Parenthood's patients who have made the decision to have an abortion and how they believe it was the right decision for them. One of our patient advocates, in sharing her abortion story, said that after carefully weighing her options, she decided to have an abortion because she was living in an abusive environment, which had taken a significant toll on her psychological health. And she said having an abortion allowed for her to finish school and get into a better living environment and obtain the necessary treatment and therapy to address the psychological issues she had experienced. Another said that her decision to have an abortion has allowed her to pursue and obtain a master's degree and economic stability because she was able to develop and have a successful career. Regardless of why these individuals have chosen to have an abortion, the decision was theirs to make. It was not a matter or should have ever involved their employer or their school administration or anyone else. These are private medical decisions that are based on an individual's inherent right to hold personal autonomy over their own bodies, their health care, and the trajectory of their lives. Abortion is health care and should be treated as such. I do encourage that you support Senate Bill 147. Thank you.
Thank you. Representative Johnson?
Thank you, Madam Chair. I'm just curious, what's the annual revenue of Planned Parenthood?
That is not a matter of why we're here today talking about this particular piece of legislation and has nothing to do with the legislation. This is about discrimination against a person via their employment, and that is what I would like to speak to today.
I know you would like to confine it to that, but every corporate
Representative,
revenue
please keep
is
your
relevant.
questions relevant to the bill at hand. I would ask all the committee members do that. Thank you. Any other questions? Representative Wozniak?
Thank you, Madam Chair. What are the requirements for an employee to report to an employer that they're pregnant and they're requesting time off? What is that requirement?
Those requirements are based on, they are not necessarily required. Those are based on each employer's own personal decisions to be able to make those requirements. And so based on...
how do they verify that?
I'm sorry, I am not an employment attorney or expert, and therefore I can be certain that that is left up to the employer or the individual who is making the request.
Okay. Sounds like there could be uncertainty in the middle of that discussion. Thank you.
Seeing no other questions, thank you for your testimony today.
Thank you.
We also have written testimony from Catherine Boussard from Salt and Light Global, not wishing to speak. That testimony will be recorded in the minutes. Also, William Wagner from the Great Lakes Justice Center opposing the bill, same as Catherine Boussard, not wishing to speak, but their testimony will be recorded. Supporting the bill but not wishing to speak, Judy Karenjeff from the League of Women's Voters. Stephanie Cruz from Heritage Action opposing the bill, not wishing to speak. We have a substitute that we will adopt before getting to an amendment from Representative Johnson. There is a motion to adopt the substitute from Representative Arbit. Madam Clerk, please call the vote.
To adopt the substitute H1 to Senate Bill 147. Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Substitute H1 to Senate Bill 147 is adopted.
I have an amendment offered by Representative Johnson for Senate Bill 147. Representative Johnson, do you wish to speak to your amendment?
Yes, thank you, Madam Chair. I move that my amendment be considered as a ministerial or religious exemption in line with the U.S. Supreme Court decisions and what many states have adopted as well, that give equitable accommodation for all citizens.
Thank you. Representative Johnson makes the motion to adopt her amendment. Madam Clerk, please call the vote.
Chair Breen.
No.
Representatives Edwards.
No.
Carter.
No.
Hope.
No.
Arbit.
No.
Devendorf.
No.
Hoskins.
No.
Cerniglu.
No.
Fink.
Yes.
Wenzel.
No. Yes, sorry.
That's a yes, right? Wenzel. Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 5 yeas, 8 nays, 0 pass. The amendment is not adopted.
Thank you. I will now take a motion from Representative Hope to report. Oh, I'm sorry. Hold on. Do I have to report Senate Bill 147 as substitute H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
Nope.
Wozniak.
No.
Outman. Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Senate Bill 147 is reported with recommendation as substitute H1.
Thank you, Madam Clerk. We are now going to take up Senate Bill 18 from Representative Chang. Representative, would you, sorry, Senator Chang. We're bouncing back and forth, guys. Please give me a little grace. Thank you. Senator, thank you for bringing this bill. I'm just going to preempt this by saying I think it's fabulous and it is long overdue. Please tell us about it.
Thank you so much. Thank you, Chairwoman Breen, and thank you to committee members. Glad to be back in this room. Excited to talk about Senate Bill 18, which would designate January 30th of every year as Fred Korematsu Day here in Michigan. Would note that this is identical to a bill from Representative McDonald, which is also being considered in the House. Very grateful to have worked with Representative McDonald, Senator Singh, and members of the Asian American community for years on this legislation. And Many of you know this history, but in 1942, President Franklin Roosevelt's Executive Order 9066 authorized the Secretary of War to require all Americans of Japanese ancestry to be placed in incarceration camps. Over 100,000 Japanese Americans were ultimately incarcerated. And Fred Korematsu was one of many Americans, citizens of Japanese ancestry, living on the West Coast during World War II. Fred Korematsu took a stand at the young age of 23 to defy the executive order and refused to go to an incarceration camp. He was arrested for refusing to comply with that order. He later moved to Michigan, where he met his wife, Catherine. The decision in Korematsu versus the United States unfortunately upheld the legality of Japanese American incarceration camps because of military necessity, though our nation did formally apologize to the community in the 1980s and authorize reparations. Korematsu's conviction was later overturned. And then in 1998, Korematsu was awarded the Presidential Medal of Freedom, our nation's highest civilian honor, by President Clinton. Fred Korematsu's determination to fight for justice and his faith in democratic principles and the Constitution exemplify some of the best qualities in Americans. Fred Korematsu left a tremendous legacy as a champion for civil liberties and for constitutional rights, and it takes an enormous amount of courage for any individual to stand up against and defy unjust policies that seek to exclude entire groups of people based on their ethnicity or country of origin. So I'm very hopeful that the state that Fred Korematsu once called home will formally recognize his sacrifices as well as his contributions to our great nation. I believe it is critical that more Michiganders learn about Fred Korematsu as an important figure in Asian American history, in Michigan history, and United States history. In the past few years, during the rise of anti-Asian hate incidents, more and more community members have expressed how important it is that we all learn about the contributions and struggles in our history. By taking action on this bill, we would join several other states who have already taken this step forward to recognize January 30th as Korematsu Day. This bill did pass unanimously in the Senate and would welcome your support. Thank you.
Thank you, Senator Chang. This lawsuit was required reading in law school. It's a terrible chapter in our nation's past, and I'm glad that we are able to learn from our mistakes and move forward. And on a personal note, my district is 40% minority. It is very heavily Asian and Indian. This is going to be, I know, very much welcomed by the people in my district. You mentioned that other states are have or in the process of adopting Fred Korematsu Day. Do you know how many, by chance?
You know, I should really know that number off the top of my head, and I apologize, I don't. But I do believe that Karen Korematsu is on Zoom, and she would be able to help answer that question.
Are there any questions from the committee before we go on to the video testimony? Noah Arbit?
Thank you, Madam Chair. Senator Chang, this bill brings a smile to my face. And I just want to say that I am so grateful for you and your leadership putting this forward on behalf of the Asian American community, but on behalf of all of us, because as you said, you know, Fred Korematsu's, heroism and legacy just speaks to the greatest American character, possible. And I'm honored to have the opportunity alongside, I know my colleagues here to be able to vote on this bill. This is exactly the direction that we need to be going in as a state. So I'm very grateful to you for bringing this forward. Thank you.
Thank you. Thank you.
Thank you. We have Dr. Karen Korematsu via Zoom here to testify. Thank you. Welcome.
Thank you. Good morning, everyone, and thank you for letting me speak a few words about my father. I'm speaking to you from San Francisco, so I'm not quite awake yet, but I'll try. I have been to the great state of Michigan in February when it was very cold, and speaking to a subcommittee at that time. But thank you for considering having a day that's in perpetuity for the state of Michigan, Fred Korematsu Day of Civil Liberties and the Constitution. I know my father and my mother would be very happy about this. But most importantly, it's about education. It's about the education and the history of our country, and hoping to stop making the same mistakes of the past. My father was just briefly, born in Oakland, California, in the San Francisco Bay Area, and he always thought of himself as an American citizen. But he experienced racism. He was in high school. He refused a haircut, told to go down to Chinatown and to not come back to that barbershop. He was refused to be served in a diner. And told to go to Chinatown and never to come back. So, those kinds of experiences add up. And before the World War II, President Roosevelt, if you will recall, issued a peaceful time draft. This was back in 1940. And so my father and his three Caucasian buddies decided that this is after high school, that if they enlisted together, they could stay together. And then when they went to the post office back in those days, the military officer was handing an application to my father and his three Caucasian buddies. But because my father's name was Korematsu, the military officer said, "We have orders not to give anyone who is Japanese an application." And my father was terribly hurt and embarrassed, but he still wanted to serve his country. And he worked in the shipyards before Pearl Harbor. But the day after, he was fired because it was a military shipyard. But he had learned about his rights as an American citizen in high school, studying the Constitution. So when President Roosevelt issued Executive Order 9066, he just thought that it was wrong. I mean, he had moral principles of right and wrong. He was never angry or bitter. He just said, "I'm an American citizen. I have rights. I've done nothing wrong. Why should I go to a prison?" And so that's why he refused the order and was arrested. And after his bail hearing, he was sent over to the Tanforan Assembly Detention Center where everyone else was. And he was ostracized and vilified from his own Japanese American community for standing up. And again, when the evidence was found that proved there was no military necessity, and his case was going to be reopened in 1983, almost 40 years later, again, the Japanese American community ostracized him and said, and vilified him, that said, if you reopen your case, you're going to lose our chances for redress and reparations. But my father never gave up hope. And when his conviction was vacated in 1983, he continued to crisscross this country to speak up on behalf of others who also had experienced racism, especially the Muslim Arab Americans after 9/11. In 2001, when his Supreme Court case was cited again as a possible reason to round up Arab and Muslim Americans and put them in American concentration camps. And so he even spoken out until 5 months before he passed away, and then gave me the charge to carry on with education. And I work with all teachers and state educators, including Michigan. And I've spoken to several University of Michigan, as my father did, and the importance is that we need to appreciate and learn about our differences, and know that we have rights as an American. There have been 6 other states, to answer your question: California, Hawaii, Virginia, Florida, Arizona, and then New Jersey earlier this year, that have signed this bill in perpetuity for Fred Korematsu Day of civil liberties in the Constitution, and New York City. And so if my father were here, he would say to you, stand up for what is right and don't be afraid to speak up. And what I say to you, that Fred Korematsu was one man who made a difference in the face of adversity, and so can you. Thank you.
Thank you very much, Dr. Korematsu, for your testimony, and we thank you for your father's contributions to society, and it's terrible that this had to occur even in the first place, and hopefully we can learn from this history to make sure we do not repeat these mistakes going forward. Seeing no questions from anybody here on the committee, we are going to now turn to Naoke Wake, Professor of History. And because we are running short of time, I'm hoping that they can keep their testimony to about 1.5 minutes.
Very much. I'm Professor Naoko Wake. I am Professor of History at Michigan State University. I am also the Director of Asian Pacific American Studies program at the state. I'm here today to support the establishment of Fred Korematsu Day of Civil Liberties and the Constitution in perpetuity in Michigan, so that Michiganders can better observe, celebrate, and reflect on this key moment in the U.S. history. Michiganders already have been observing Korematsu Day, recognized by proclamation by the former governor Rick Snyder and the current governor Gretchen Whitmer. Korematsu Day has had political support across the aisle because it embodies one of the most fundamental American values, that is, civil rights for all. I teach Michiganders at Michigan State, where Korematsu history is taught everywhere. It's not only an Asian American issue, it is also an important lesson in US history, and I would say US history of international relations. The reason for this is the fact that Korematsu's dedication didn't end when a US district court in 1983 overturned Korematsu's guilty conviction. Most notably, he helped pass the famous Civil Liberties Act of 1988, which gave a public apology and compensation for former Japanese American camp inmates. He wanted something bigger than a personal vindication. He wanted a collective victory that ensured that this will never happen again to any American citizen. My students at Michigan State take delight in learning about Korematsu's story because it teaches them a way to grasp their nation's past and present. They proudly tell me that they talk to their families and friends about what they learned, and they also tell me that they feel this is a story that goes beyond America's national borders and travel around the world. They are proud of Korematsu as part of US contribution to the world history. These students will benefit from knowing that their elected leaders support their desire to learn. As an educator and a scholar, I urge you to make Korematsu Day perpetual. Thank you very much.
Thank you very much, Professor. Seeing no questions, we are now going to move on to Professor Roland Huang. Hello, sir. Welcome to Judiciary. We're looking forward to your testimony
Madam
of
Chair.
about 1 minute long on Fred Korematsu Day.
Thank you, Madam Chair. I am a teacher in the Asian Pacific Islander American Studies program at the University of Michigan. And on behalf of the MAPAC, I also run the Korematsu program recognitions each year on January 30th, and was a member of the Milestone Committee of the State Bar of Michigan. I just want to mention that Fred and his wife, Catherine, never rested in terms of teaching about due process and equal protection. And they were very active in pursuing, educating people about that. They ventured to Michigan in 1986 for the commemoration of the Justice Murphy's dissent legal milestone in Harbor Beach. So they could spread the word about the importance of adhering to due process and equal protection. For years, from 1995 to 2005, Catherine and Fred attended my class, Asian Americans in the Civil Rights Movement, to talk about equal protection and due process. And so with that, I urge you to support the Fred Korematsu Day in perpetuity. It's an opportunity to learn about civil liberties and due process. Thank you very much.
Thank you very much, sir. We appreciate your testimony. Seeing no questions, we are now going to move on to the voting. We have a substitute for Senate Bill 18 before the committee. I have a motion from Representative Hoskins to adopt the substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion from Representative Edwards to report Senate Bill 18 as substitute H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. Senate Bill 18 is reported with recommendation as substitute H1.
Thank you. I'm going to have to change the order up real fast. We are now going to return to House Bills 4120 through 4125. I will now take a motion from Representative Edwards to report House Bill 4121 with recommendation. 4120 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4120 is reported with recommendation.
Thank you. I will now take a motion from Representative Carter to report House Bill 4121 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4121 is reported with recommendation.
Thank you. I will now take a motion from Representative Sergaloo to report House Bill 4122 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4122 is reported with recommendation.
Thank you. I now take a motion from Representative Hope to report House Bill 4123 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4123 is reported with recommendation.
Thank you. I will now take a motion from Representative Arbit to report House Bill 4124 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4124 is reported with recommendation.
Thank you. I have an H1 substitute for House Bill 4125 before the committee. I'll take a motion from Representative Devendorf to adopt H1 sub. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I now take a motion to report House Bill 4125 from Representative Edwards as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel. Yes. Wozniak.
Yes.
Outman. Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. House Bill 4125 is reported with recommendation as substitute H1.
Thank you. I appreciate everybody's patience. We are obviously going to be going over, so we have about 20 minutes here or so to bring up House Bill 4176 from Representative Tyrone Carter, as well as Senate Bill 32 from Senator Santana.
Thank you, Chairwoman and members of the committee. It's an honor to be here today and patiently waiting, so I appreciate that. But I want to thank you all for having me here, as well as Senator Carter here today, Representative Carter. I'm doing what you did earlier. To discuss Senate Bill 32, which amends the Public Act of 390 of 1978. This bill will allow for law enforcement agencies to enter into a tuition contract with recruits and pay for the initial training in turn for up to 3 years of service to that agency. As some of you may already know, I have been working on this issue for 5 years. Actually, this issue started right here in the House. And I'm excited to move this bill along and provide relief for the city of Detroit, and also give other law enforcement agencies the opportunity to entice recruits and their organizations by offering to pay for their initial training. I had communities call me and explain their frustration that we gave them grants to offer to boost recruitment, but then these agencies were concerned that they could not spend the spend of the money that the new recruits would actually leave after receiving that initial training. The difference of the two changes between the bills that were introduced earlier in the versions, Senate Bill 375 from the last session, which was passed from the committee to now. First is the length of service that can be entered into for the tuition contract with law enforcement. Those changes go from 3 to 4 years, and better reflect the law enforcement's request for the actual training timeframe. As some of you may remember, 2 versions of the bill had passed through Judiciary last session, Senate Bill 375, which had 3 years of service, and the other bill that had 5 years of service. So the compromise was between the 2 versions was the 4 years. The second change that is codifying the Supreme Court ruling that will allow some expectations to the tuition contract ruling decided in the Sands Appliance Services Incorporated versus Wilson. We also have joining us via Zoom testimonial was Hassan Beydoun, as well as Detroit Council and Senior Advisor to the Mayor to explain any other details that you need regarding the bill, and also the representative here. Also, I just want to say that there were some conversations or questions regarding the 2 bills, the House version of the bill as well as the Senate version of the bill. The bill that was introduced in the House is similar, the same as what was introduced in the Senate, to answer any questions. So with that said, I'll answer any questions if there's any by the committee members.
I'm going to ask that we hold questions until we hear from Representative Carter and we take the Zoom testimony, and then we'll do questions at that point. Thank you.
Yes, well, I want to thank you all for hearing the testimony, and I hope that we will have swift passage of this bill. It has been a 5-year time frame, and definitely with all of the public safety issues that we see currently in our state, it is an opportune time to make sure that we're getting good recruits into our public safety servants' roles, as well as making sure that it is an opportunity to make sure that we keep Michigan safe. So thank you all for your time, and I will turn it over. Thank you so much.
Thank you, Senator.
Thank you, Senator. Madam Chair and this honorable, wonderful judiciary body, I think that Senator put it all in perspective. We've worked on this for the past few years. And the reason being is there's only two two department-run academies. But there are also cities that will sponsor students to go to the academies. And once they graduate, they're more marketable. So cities have invested these monies in training into these cadets that become officers, and now they're more marketable. They leave. Many of them leave. Matter of fact, many other departments will tell them to go to places that will provide the training, and then they will hire them, which is really disrespectful to the taxpayers of whatever entity represents them. So with that, we've come up with a way that if you go, we want a return on our investment. And if you don't join law enforcement, then you don't have to do that. So I will take any questions. I know we also have Deputy Chief LaValle on that can talk about the cost. I know that it's 30 credit hours at Schoolcraft, and it comes out to $5,600. But if you hire them and you train them in the meanwhile, I know that the city of Detroit, it's $35,000. So with that, I will turn it over to any questions, or you want to go?
I'm going to ask that we hold questions until after we take the video testimony. We have Hassan Beydoun on Zoom.
Good morning, Madam Chair and committee members. I know you all are crunched for time, so I'll stay on to answer any questions that committee members have, and I'll pitch it over to Deputy Chief LaValle if that's all right with you.
Works with me. Thank you. Deputy Chief?
All right, good morning. David LaValle. I'm the Assistant Chief with the Detroit Police Department. I oversee professional development, which includes training and human resources and recruiting. And as was already stated, we do hire a number of individuals. Since January of 2020, we've hired over 700 new police officers. But during that same time, we've had 839 that have left the police department for a variety of reasons. But 312 of those 839 left to go to other police agencies to work. And so we are one of the few agencies in the state that run our own police academy. We hire individuals and pay their full wages while they're going through the 6 months of training it takes to become a police officer. And then we're finding that many individuals are leaving shortly thereafter to go to work for other police agencies in the surrounding area. And so over the last couple of years, the cost for us to train and pay those wages for those 312 individuals that left was just short of $11 million. And so, as was already also stated, our intent is for an individual to hire with the Detroit Police Department with their intent to be to continue to work for the Detroit Police Department. And we do understand that, some individuals decide that maybe police work isn't for them. And we're not looking to try to keep those individuals in police work because we think that would be dangerous. But we're trying to focus on people who come to Detroit, use us for the training experience, and then leave shortly thereafter, and leaving the citizens of Detroit with the bill to pay for all that training that a different community is benefiting from. So our hope is that we would be able to recoup some of those costs. Thank you.
Thank you, sir. I believe you said there was one other academy in Michigan besides the Detroit?
Michigan State Police.
Okay. And Schoolcraft offers a program as well?
Well, Schoolcraft and some colleges offer what we call MCOS pre-service. But a city can sponsor you, but with Detroit and Michigan State Police, you are paid trainee while you're there. So there's different costs to it. You can pay your own way, but with the Detroit Police Department and Michigan State Police, they pay you as they train you.
Okay. So I just want to make sure I have this correct. About 720 officers have been hired in recent years, but yet over 800 have left.
No, 300.
312 have
well,
left.
800. I mean, there's retirements,
Right.
Stuff, but the people that have come in and left within that matter of years is around 300.
Okay. And it's about $35,000 to put them through the academy?
Yes.
Okay. Thank you. Representative Arbit?
Thank you, Madam Chair. Thank you, Representative Carter, for putting forward this legislation. West Bloomfield, where I represent, West Bloomfield is among the agencies that sponsors trainees, through the program and sort of, pays their way. And this is a massive issue for West Bloomfield PD. because we have a lot of individuals who we put through the training and go through and then they leave for places where I guess there's a perception of potentially higher crime or whatever. This is something that my police chief has discussed with me at length. Is that especially with areas and like WPD, which are perceived to have the resources to be able to sponsor folks, and then they leave. So this really, and I just want to address the committee that this legislation really does address a very acute issue in municipalities and police departments across the state. So I'm very excited by this legislation and appreciative of your work to put it forward.
Thank you, Representative.
Representative Fink.
Thanks, Madam Chair. Rep. Carter, thanks for bringing this legislation forward. My understanding from reading it is that if we were talking about a police agency that didn't have their own academy, but did pay for somebody to go to Schoolcraft or Washington or wherever, that the recoupment that we're talking about here could also be for that form of tuition. Do you agree with that?
Yes.
Okay, thank you.
Representative Sterngaloo.
Thank you. So I heard it mentioned that, obviously we want to make sure that people who are not, find that they're not suited for police work can still remove themselves from that job. So how would it be determined, who would have to pay back and who wouldn't? Like, is it if they personally, quit and then worked for another agency, or if they're, I guess, let go, or how is that determined?
Well, it's kind of easy, and I've watched it happen. I've been to Detroit police graduations, and other cities would be sitting in the audience. So they have to go with their MCOS licensing, and there's a database. So if an officer just stops working police work altogether, their license will lapse, and they won't go to another department. But cities can check in, and when officers apply to another department, they usually send that letter and say, hey, we have this recruit or this person that we're interested in hiring, and they go through personnel.
Seeing no other questions before the committee, I just want to note that I want to thank you for bringing this forward. We definitely have some problems to fix with first responders. We don't have enough policemen. We don't have enough firefighters. But we need to make sure that they are trained and paid appropriately, and this is definitely an avenue to help make that happen. We are not going to be voting these out today, but we will definitely keep talking about it, and I look forward to voting them out hopefully the next time we meet. I am now going to take a motion from Representative Hoskins to adopt the minutes from the last meeting. And those minutes are now adopted. And seeing that we have no absent members and no further business before the committee, we stand adjourned.